According to my next guest, it's time for family law solicitors in Ireland to focus more on mediation and corroborative law instead of taking the vast majority of separations and divorces through the courts. This, she argues, would save clients large amounts of money and make the whole relationship breakup process much less stressful. She's written a new book called Appropriate Dispute Resolution in Ireland, a handbook for family lawyers and their clients. A little bit of a mouthful, but I think she'll make it interesting, if you like. I'm delighted to have Josepha Madigan with me in studio this morning. Good morning to you.
Good morning, Miles. Thank you for having me back.
First of all, you are a family law solicitor yourself, but you're also a trained mediator. Why did you opt to go down that particular route yourself?
I suppose, Miles, if you include my traineeship as a solicitor, I'm nearly 20 years practising in the area of family law. And after maybe 10 to 12 years, I saw the destructive element to family law down in the family law courts. And the fallout of that for the families involved, for the parents, and more importantly, for the children. The adversarial court process is very difficult for people going through that. I mean, it's not just an emotional difficulty for people separating or divorcing, it's also the adversarial system, which in some ways compacts that or compounds it for them.
Is the adversarial system appropriate, in fact, at all to family law?
In my view, no. There will always be a place for litigation. Litigation is always going to be necessary, particularly in light of your last piece, in relation to child, emergency protection orders. But I do honestly believe that the majority of clients can resolve their dispute outside of court and without a judge-imposed outcome. And,
obviously, there's very little information, there's very little knowledge of what happens in family courts because it is, for very obvious reasons, difficult to cover what's going on in family courts. Do judges often say to people involved in a family law case, look, go away, mediate, go away, see if you can sort this out? Does that often happen, or do the judges sort of sit there and allow cases to proceed and families to be literally torn apart?
The county registrars in the circuit court during what they call the case progression hearings can they can actually recommend that parties go to mediation, but they can't force them to do so.
Yeah, that's all they can do. They can just recommend.
Exactly. And in the High Court, there's the case management system. They can also do that. Unfortunately, by the time you get to court, it can be so entrenched that the parties may not wish to avail of mediation or collaborative law, and also their lawyers may not want them to do so.
Yeah, OK, well, that's another point. So when you get to the circuit court, essentially, the die probably is already cast.
It's never too late to avail of a dispute resolution mechanism. I think that's very important to say. And I have actually mediated cases where there have been court orders put in place and the parties themselves get so fed up of not alone the cost in terms of financial cost, but also the emotional cost involved, that they say, look, we're going to give mediation a go and see if we can resolve this outside of court, and often they do.
Now, you're wearing two hats because you are a mediator, you are also a solicitor, but how does the legal profession view mediation? Does it see mediation as a competitive threat?
Yes, I have my detractors, Miles. There's no question about that. However, I launched the book last night, Appropriate Dispute Resolution. The Minister for Justice launched it. There was a great attendance from family lawyers there. There wasn't a book left, which is a good sign.
Yeah.
I think
it's not cheap.
No, and I think it's €44. It's not too bad, and it is a book that's easy to ingest for clients as well as for family lawyers, and it sort of covers that gap where there is no information about these mechanisms, and there's no question about it. I would make a lot more money as a lawyer, and I do, in bringing cases to court. There's no doubt about that. And what people don't realise, and lay litigants don't realise, is that ADR work, and I'm also a collaborative practitioner, so I suppose I wear three hats, it's more demanding on me than it is to hand a brief over to counsel and go down to court.
But you will always recommend to a couple coming to you, or to individuals coming to you, as well, obviously a couple isn't going to come to you if it's an adversarial thing, try mediation first. Yeah,
well, we have a statutory obligation as solicitors to advise that clients try mediation. It's on the option menu, if you like, and there's the section 5, 6 and 6 certificates, but I won't bore you with that detail. But I suppose the point that I am making is that do we really walk the walk and talk the talk? You know, we do have to sign a certificate saying that we advised our clients to avail of these processes. But how far do we really push it? At the end of the day, a client comes into you, and as a lawyer, you can steer them in a certain way. And if 90% of cases settle outside of court in the family law arena, which they do, there's absolutely no reason why they shouldn't resolve themselves earlier in the dispute.
Were there many barristers at your launch last night? I wouldn't
Not
have thought
as many
much
as the solicitors know.
I
But
wouldn't
in
have
fact,
thought there's that much
my
in it
mother
for
and
them.
my sister are barristers.
Yeah, but they would have perhaps different reasons for attending.
Exactly.
Okay, in a broad sense, tell us exactly what mediation is. What happens when the couple whose marriage is falling apart, who probably are very, very raw and who don't necessarily want to meet each other, across a crowded desk. What happens when they go into a mediation session?
Well, first of all, to preface that by saying what mediation isn't. And there's a lot of misinformation, as I said, out there about what mediation is. It's not counselling. It's not therapy. It's a very structured process. And particularly as a lawyer mediator, we're obviously trained to sort of be involved in that sort of way of dealing with things in an organisational way. So really what your role is as an impartial, neutral third party who facilitates the clients or the couple in reaching proposals. These proposals can then be incorporated into a separation deed or into consent terms by their respective lawyers. So an average in mediation would take 3 to 6 sessions, and that deals with the full ambit from, the family home to access for children. I hate using legal terms, but it's the way that it is. One of the wonderful things about coming to a lawyer mediator is you can anticipate what the solicitors will be looking for. So there's very little gap then between what's in the mediated agreement and what's going to be incorporated into consent terms.
You won't be leaving anything out.
And the cost saving, Miles, is enormous.
Give us an idea of how much money you can save.
Well, I know
having 6 sessions of mediation, coming up to with an agreement, which is then brought to both solicitors, and everything is signed, sealed, and delivered, as opposed to going to court, going even to the circuit court.
Well, you're talking at least 60% cost saving. There's no doubt about it.
What are the potential costs of going all the way to the family court? Are we talking 20,000?
Yeah, you're talking 15,000, 20,000 probably for circuit court.
So you can save 60% of that by going to mediation.
Absolutely, yeah.
And still employing 2 solicitors.
Yeah. And obviously the collaborative process is a different sort of mechanism, and that's where sometimes it's recommended or some clients rather would prefer to avail of the collaborative process where they feel there's a slight power imbalance or they feel vulnerable because you have your lawyer present with you, and that's an advisory role.
And to what extent does the mediator, or can the mediator, become a persuader? An agreement must be mutually acceptable to both parties. How proactive can the mediator be when it comes to persuading one or both parties to take a certain course of action?
Well, there are certain styles of mediation. I mean, there is sort of the facilitative mediation, there's directive mediation. At the end of the day, it's the parties that control the outcome and they dictate the speed of the process or otherwise. So you're really helping them, and you're trained to do so that they reach mutually agreeable solutions themselves.
A text comes in which says mediation has no way of compelling a party to adhere to an agreement. Also, it can be very costly with nothing achieved. I mean, that can happen.
That absolutely, and certainly I hear that a lot. What I would answer to that is that there's, notwithstanding that, even if it, inverted commas, fails, a lot of the time it narrows the issues between the parties. So even if they have to go to court, there's a huge amount of work done already.
Yeah, so you can have, to be facile about it, you can have at least decided who's going to get the record
Exactly,
collection.
and a lot of couples, unfortunately, are separating or divorcing. You have to remember, in the past 25 years, the divorce rate is risen by 600% to 250,000 people, and so a lot of these people don't want to go to court. They really don't.
What kind of cases would leap out at you as being totally unsuitable for mediation? And they do exist.
Yeah. Well, again, when you're talking about the success of a mediation or otherwise, one of the most important aspects to mediation or collaborative law is the screening process. And again, not everybody is going to be suitable for this sort of dispute resolution. They have to want to do it, for starters.
Okay.
And most clients are going to be co-parents, and they're going to want to communicate for the rest of their lives because they have children together. So they're the sort of people that will want to do it. If there are areas of domestic violence, for example, or abuse, there's various different forms of abuse, as you know. It may not be very obvious, as in physical abuse. Then they may not be suitable, and probably aren't suitable.
If one of the parties is generally the male, let's face it, is particularly fractious and has a particularly domineering personality, obviously, without there being any physical abuse involved, but would you, if two people came to you and there was that clear disparity, would you say, go somewhere else?
Yeah, well, I mean, that's what we would call a power imbalance, and quite a clear one. And that does absolutely happen. And sometimes if the person feels that mediation isn't for them, they may try the collaborative law route. And if that doesn't work, well, then they'll have no option to go to court.
A memorandum of understanding is drawn up by a mediator.
Yes.
Is that a legally binding document? At what point can it become, or does it become legally
No,
binding?
it's not a legally binding document, but it can be incorporated into a legally binding document, and actually can become a legally binding document if both parties consent in writing. It's that simple and that straightforward. And I really feel very passionately about it when I meet clients and when I do a collaborative or mediation case, and the benefits that they receive by going through the process and the savings that both emotionally and financially. And that's why I wrote this book, because I wanted people to know about it. And I think that, clients need to go into their lawyers and say, I really don't want to go to court on this unless I absolutely have to.
And is the message getting out there, or are we too attached to our adversarial system? Are our solicitors, and more particularly our barristers, too attached to the adversarial system?
The tide is changing, in my view. I mean, the role of the lawyer is becoming more multidisciplinary. We're mediators, we're collaborative practitioners. The mediation bill is coming in. So whether people like it or not, it's going to be there. There's going to be a statutory duty on the barristers to advise about mediation as well as solicitors. So I honestly believe there's more information out there now, and it's becoming more prevalent.
We have a question not specifically related to this, but you might be able to handle it. Can you be forced to have a divorce if you don't want one because of religious convictions?
You can't stop somebody divorcing you, put it that way. You can run, but you can't hide. But if you're served with the divorce civil bill, certainly after a period of time, if you don't attend or you ignore it, you'll get a divorce in their absence.
So basically within 5 years, it's going to happen.
Well, you have to be 4 years separated.
Assuming you're separated, obviously.
Yes, exactly,
so it's going to happen one way or the other.
Yeah.
So essentially you can't avoid it. Josepha, thank you very much
Not at all,
for
Miles.
talking to us. The book,
Pleasure to
once
talk
again,
to.
is Appropriate Dispute Resolution in Ireland, a handbook for family lawyers and their clients.